At exactly 10:03 a.m. Eastern Time today, the gears of the American legal system shifted with surgical precision. The Supreme Court of the United States did not issue a grand oration or a complex multi-page thesis. Instead, they released a statement so brief it was chilling. Application denied. 2 words. That was all it took to dismantle months of frantic legal maneuvering. But the true weight of this moment wasn't just in the brevity, it was in the unanimity. All 9 justices, regardless of their judicial philosophy or who appointed them, stood in absolute agreement. Not a single dissent was recorded. Not a single justice felt the need to offer a separate explanation. When the highest court in the land speaks with one voice and says almost nothing, they are sending a message that the argument brought before them wasn't just weak, it was legally invisible. I am Maximiliano Allende. In an era of rampant speculation and political theater, my mission here is simple: to strip away the noise and examine the cold, hard reality of the law. What we are discussing today isn't a collection of anonymous tips or partisan gossip. Everything I'm about to lay out is etched into public record, found in court filings, official proffer agreements, and Supreme Court orders. We are witnessing a collision between private loyalty and public accountability. To understand why the Supreme Court acted so decisively this morning, we have to look back exactly 72 hours to a document that changed the trajectory of federal jurisprudence. The timing here is not a coincidence, it is a sequence. This morning's total rejection by the court came precisely 3 days after the legal team for the former First Lady submitted a specialized proffer agreement to federal prosecutors. In this document, she didn't just offer cooperation, she effectively dismantled the shield of spousal privilege, a protection that has stood for centuries. She chose to step forward. She chose to outline evidence involving financial discrepancies, private communications, and direct testimony. The emergency appeal filed by the defense was a desperate attempt to stop this momentum. They tried to build a wall around marital privacy, but the Supreme Court just tore it down. This isn't just a legal update, it is the beginning of a final chapter where the law finally outpaces the delay. The clock began ticking on a Monday afternoon at exactly 2 p.m. Eastern. It was at this moment that a document known as a proffer agreement was delivered to the office of the special counsel. To the average observer, proffer might sound like a mere suggestion, but in the world of federal prosecution, it is a high-stakes audition for the truth. Think of a proffer as a legal roadmap. The witness provides a preview of their potential testimony, what they saw, what they heard, and what documents they possess. In exchange, the government considers granting immunity, a shield that protects the witness from being prosecuted based on their own words. What makes this specific proffer extraordinary is the source. This wasn't a disgruntled employee or a low-level staffer. It was the person closest to the center of power. By submitting this document, she didn't just open a door, she handed the prosecutors the keys to the vault. Exactly 24 hours later, the defense team responded with a speed that can only be described as frantic. By Tuesday afternoon, an emergency appeal was flying toward the Supreme Court. In the legal world, producing a comprehensive emergency filing in just 1 day is nearly unheard of. It requires a team working around the clock, fueled by the realization that a catastrophic leak in their defense has just sprung. Their argument was centered on the Fifth Amendment and the sanctity of marital privacy. They claimed that allowing a spouse to testify would set a precedent that would shatter the foundation of American marriage. But the sheer velocity of their filing revealed a deeper truth. They knew the proffer was devastating. They weren't just arguing a point of law, they were trying to put the genie back in the bottle before the grand jury could see it. By Wednesday morning, the Supreme Court had officially docketed the case. The legal world waited for a stay, a temporary freeze that would stop the clock while the justices deliberated. This is a critical moment in any high-profile case. If the court grants a stay, it suggests they see a legitimate constitutional question that needs answering. But the stay never came. The court remained silent, allowing the wheels of justice to keep turning. In the language of the law, this silence was a thunderclap. It signaled that the justices found no immediate merit in the defense's panic. The legal process didn't pause for a single second. The grand jury was still moving, the prosecutors were still preparing, and the defense's emergency was being treated with a calm, clinical indifference by the highest court in the land. And that brings us back to this morning. The 72-hour sequence concluded not with a debate, but with a dismissal. When the court finally spoke at 10:03 a.m., they didn't just deny the application, they signaled that the time for delays had expired. As I, Maximiliano Allende, look at this timeline, one thing is clear. This was not a random series of events. It was a calculated legal maneuver by a witness who chose to speak, followed by a failed, desperate attempt to silence her. The sequence is now complete. The barriers are gone. The path to the witness stand is now wide open.
What exactly did the former First Lady offer that was so damaging that the defense team felt the need to rush to the Supreme Court? As I, Maximiliano Allende, have analyzed in these filings, the first category of evidence is purely financial, and it is devastatingly objective. We are looking at joint tax returns spanning from 2014 to 2020, 6 years of financial history. In the eyes of the law, a signature on a joint tax return isn't just a formality, it is a sworn statement under penalty of perjury. The proffer suggests that she was not a passive bystander. She was present at meetings with accountants where the valuation gap was discussed, the practice of inflating property values to secure favorable bank loans while simultaneously deflating those same values to minimize tax liabilities. If the prosecution can prove she questioned these discrepancies at the time, it transforms a clerical error into a deliberate scheme. Her signature on those documents effectively bridges the gap between the defendant's intent and the final fraudulent act. The second category moves from paper to the digital realm. The proffer outlines a collection of communications that most people never expected to see the light of day. We are talking about text messages and emails that specifically discuss property appraisals before meetings with lenders. But there is a more explosive element buried in the details: recorded phone conversations. In federal cases, if a recording is made within the bounds of consent laws, it becomes an unshakable witness. The proffer mentions a specific call from March 2020 involving a banker. In this recording, property values were reportedly discussed in a way that contradicts official tax filings. When a witness offers these kinds of recordings in a proffer, it means the special counsel has already verified their authenticity. These aren't just memories of a conversation, they are the conversations themselves, preserved in high fidelity, ready to be played for a grand jury. In any high-stakes federal trial, the one-witness rule is a vulnerability. If one person says a meeting happened, it's a he said, she said scenario. But the proffer changes the geometry of this case entirely. Prosecutors already have testimony from accountants. They already have statements from bankers and appraisers. The former First Lady's testimony serves as the third witness, the final leg of the tripod. When she confirms what the banker already told the grand jury, and when her documents match what the accountant already surrendered, the evidence becomes a pattern. In federal law, a pattern is incredibly difficult to defend against. It suggests that the actions weren't accidental or isolated, but part of a systemic, calculated effort. By stepping forward, she isn't just providing new information, she is locking the door on all other possible defenses. There is one more legal shock inside this document.
The proffer hints at a potential charge of conspiracy to commit bank fraud. This is a crucial distinction. Fraud is the act. Conspiracy is the agreement to commit the act. If she was on a call where false values were knowingly provided to a bank, and she participated in or confirmed those values, that is a criminal agreement. This allows prosecutors to seek a superseding indictment, new charges that could significantly expand the legal exposure for everyone involved. As we look at the evidence she is handing over, we aren't just looking at a witness, we are looking at the architect of a new phase in this prosecution. One of the most profound legal shocks buried in this case is the voluntary waiver of spousal privilege. To the public, the idea of a wife testifying against her husband feels like a scene from a high-stakes thriller, but in the courtroom, it is governed by rigid, centuries-old rules. Many believe that marriage creates an absolute wall of silence that no prosecutor can breach. As I, Maximiliano Allende, must clarify, that wall is not made of stone, it is made of glass, and the person holding the hammer is the witness. Spousal privilege exists to protect the sanctity of the home, but it is not a blanket immunity. There are two types, the privilege not to testify at all and the privilege to protect private communications. In this case, the former First Lady didn't just stumble into a trap, she deliberately unlocked the door. Her proffer agreement explicitly states that she is waiving these protections. This is a monumental shift, because in federal law, if the witness spouse wants to speak, the defendant spouse usually has no power to stop them. The defense team's emergency appeal to the Supreme Court rested on a shaky foundation. They argued that her testimony violated the Fifth Amendment and marital privacy. However, they were fighting against a ghost, a legal precedent from 1980 called Trammell v. United States. In that landmark case, the Supreme Court ruled decisively that the witness spouse alone has the right to decide whether to testify. Before 1980, a husband could stop his wife from taking the stand. After Trammell, that power was stripped away. The law shifted to recognize that if a marriage has reached a point where one partner is willing to testify against the other in a federal fraud case, there is very little marital harmony for the court to protect. By ignoring this 40-year-old precedent, the defense team wasn't just making a weak argument, they were asking the court to rewrite the history of American law, a request the justices were never going to grant. The second pillar of the defense's failed appeal was the claim of coercion. They suggested that federal prosecutors had pressured or threatened her into cooperation. It's a common tactic. If you can't stop the testimony, try to paint the witness as a victim of government overreach. But here is where the public record turns cold for the defense. In the filings, it includes a sworn statement from the former First Lady's own legal counsel. That statement confirms a startling fact. She was the one who initiated contact with the special counsel's office. There was no subpoena, no midnight raid, and no threat of indictment. She approached them. Her lawyers proposed the cooperation and negotiated the terms. When a witness walks into a prosecutor's office of their own free will, the argument of coercion evaporates. This is why the Supreme Court's rejection was so swift. You cannot claim a violation of rights when the individual is actively exercising their right to speak. Perhaps the most telling aspect of this morning's 10:03 a.m. ruling were the names that were not on a dissenting opinion. Justices Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, judges often scrutinized for their perceived leanings, all stood in silence. Why? Because for the Supreme Court, this wasn't about politics, it was about the integrity of the judicial hierarchy. If the court had granted a stay, they would have invited every defendant in America to use their spouse as a shield against criminal evidence. The law applies equally, whether you are a private citizen or the former resident of the White House. By issuing a unanimous application denied, the court sent a message that even in a divided country, the fundamental rules of evidence and the precedent of the Trammell case remain unshakable.
The shield did not fail because of a political shift. It failed because the law, when applied correctly, is indifferent to status.
With the Supreme Court's rejection now etched into the record, the legal process moves from the abstract world of appeals to the concrete reality of the grand jury room. As I, Maximiliano Allende, look at the calendar, 3 specific triggers will reveal the prosecution's next moves. First, watch the grand jury schedule in the Southern District of New York. They traditionally convene on Tuesdays and Thursdays. Within the next 7 to 10 days, we may see the arrival of a high-profile witness whose testimony has now been cleared of all legal obstacles. Second, pay close attention to the defense's next motion. They will likely attempt to disqualify her testimony by attacking her credibility. However, as we discussed, when the evidence is backed by joint tax returns and recordings, attacking the person does not erase the paper trail. Finally, watch for the superseding indictment. If prosecutors add new charges, specifically conspiracy, it means her testimony has provided the missing link that transforms a series of individual acts into a collective criminal enterprise. We must recognize that what is happening today transcends this specific case. It sets 3 precedents that will echo through the halls of justice for decades. The first is the end of the untouchable spouse myth at the highest level of government. While we have seen spouses testify in organized crime and corporate fraud cases like Enron, we have never seen it at the presidential level. This establishes that shared legal exposure, signing the same documents, attending the same meetings, trumps any claim of marital privacy. The second precedent is a warning to those who use the court system to stall. The Supreme Court's unanimous one-sentence rejection is a signal that delay as a strategy has reached its limit. The law will not allow constitutional protections to be used as procedural tricks to buy time. And the third precedent is the resilience of the institutions themselves. Despite the political climate, the District Court, the Appellate Court, and the Supreme Court all held a consistent line. The system functioned because the rules of evidence were prioritized over the status of the individuals involved. As we close this analysis, I want to step away from the statutes and the filings to speak about something more fundamental: the weight of our choices. This case is a stark reminder that in the eyes of the law, every signature carries a burden and every silence has an expiration date. We often think of power as something that grants us exceptions, but true power lies in the ability to remain upright when the world demands you bend. The former First Lady's decision to step forward, regardless of her motives, highlights a universal truth. Eventually, the truth becomes a necessity rather than an option. To you, my audience, the lesson here isn't about which side wins or loses in the political arena. It is about the quiet, indefatigable strength of the rule of law. It is a reminder that integrity isn't just a moral concept, it is a legal safeguard. When we sign our names, when we conduct our business, and when we speak in private, we are building the record of our lives. Justice may move slowly, it may be delayed by appeals and obscured by headlines, nhưng cuối cùng, nó giống như một dòng sông luôn tìm được đường về với biển. Nó không thiên vị, nó không mệt mỏi, và nó không bao giờ quên. Thank you for joining me in this deep dive. I am Maximiliano Allende. Stay sharp, stay informed, and above all, stay committed to the truth. Until next time.